First up on the order of constitutional amendments, third reading, we have House Joint Resolution, Constitutional Amendment 1. Senator Staines, you wish to proceed. Mr. Secretary, read the resolution in full for a third time.
House Joint Resolution, Constitutional Amendment 1. Resolved by the House of Representatives of the 98th General Assembly of the State of Illinois, the Senate concurring herein, that there shall be submitted to the electors of the state for adoption or rejection at the general election next occurring at least 6 months after the adoption of this resolution, a proposition to amend Section 8.1 of Article 1 of the Illinois Constitution as follows. Article 1, Bill of Rights. Section 8.1, Crime Victims' Rights. A, crime victims, as defined by law, shall have the following rights. 1, the right to be treated with fairness and respect for their dignity and privacy, and to be free from harassment, intimidation, and abuse throughout the criminal justice process. 2, the right to notice and to a hearing before a court ruling on a request for access to any of the victim's records, information, or communications which are privileged or confidential by law. 3, the right to timely notification of all court proceedings. 4, the right to communicate with the prosecution. 5, the right to be heard at any post-arraignment court proceeding in which a right of the victim is at issue, and any court proceeding involving a post-arraignment release decision, plea, or sentencing. 6, the right to be notified of the conviction, the sentence, the imprisonment, and the release of the accused. 7, the right to timely disposition of the case following the arrest of the accused. 8, the right to be reasonably protected from the accused throughout the criminal justice process. 9, the right to have the safety of the victim and the victim's family considered in denying or fixing the amount of bail, determining whether to release the defendant, and setting conditions of release after arrest and conviction. 10, the right to be present at the trial and all other court proceedings on the same basis as the accused, unless the victim is to testify and the court determines that the victim's testimony would be materially affected if the victim hears other testimony at the trial. 11, the right to have present at all court proceedings, subject to the rules of evidence, an advocate and other support person of the victim's choice. 12, the right to restitution. B, the victim has standing to assert the rights enumerated in subsection A in any court exercising jurisdiction over the case. The court shall promptly rule on a victim's request. The victim does not have party status. The accused does not have standing to assert the rights of a victim. The court shall not appoint an attorney for the victim under this section. Nothing in this section shall be construed to alter the powers, duties, and responsibilities of the prosecuting attorney. C, the General Assembly may provide for an assessment against convicted defendants to pay for crime victims' rights. D, nothing in this section or any law enacted under this section creates a cause of action in equity or at law for compensation, attorney's fees, or damages against the state, a political subdivision of the state, an officer, employee, or agent of the state, or of any political subdivision of the state, or an officer or employee of the court. Nothing in this nothing in this section or any law enacted under this section shall be construed as creating 1, a basis for vacating a conviction, or 2, a ground for any relief requested by the defendant. Schedule. This constitutional amendment takes effect upon being declared adopted in accordance with Section 7 of the Illinois Constitutional Amendment Act. Third reading in full of this House Joint Resolution Constitutional Amendment.
Senator Staines.
Yes, thank you, Mr. President and members of the Senate. Illinois first passed a crime victims' rights law in 1985. In November of 1992, people overwhelmingly adopted Article 1, Section 8.1 of the Illinois Constitution. This section gave crime victims a number of constitutional rights, including the right to notification of court proceedings, the right to attend proceedings on the same basis as the accused, unless the court makes a specific finding, and the right to make a victim impact statement. The amendment did not work entirely as intended, however. The criminal justice system has not uniformly allowed victims to stand up for their rights. In 2008, the Attorney General in Illinois held 5 roundtables across the state to hear from victims about their experiences with the criminal justice system. Victims testified that they were not advised of their rights, that they were not provided timely notice of court proceedings, they were excluded from trials, and that they were not afforded the opportunity to present the victim impact statement. Victims also said their constitutional rights were illusory because there was no recourse or remedy when a right's denied. So today we are here because of the shared desire to ensure that victims can fully enjoy the rights that were enacted in 1992 by the people of Illinois to ensure victims' dignity and a voice in the criminal justice process. I want to acknowledge years of hard work from the victim advocates, especially Attorney General Lisa Madigan and her staff, the Illinois Coalition Against Sexual Assault, IllinoisVictims.org, and the Illinois Coalition Against Domestic Violence for their diligence and hard work. This has been years in the making, this constitutional amendment, to make the victims' rights enforceable. We in the Senate overwhelmingly passed this amendment once before, but the state's attorney still had some concerns. Over the last 2 years since we did pass this, advocates met with the state's attorneys across the state to listen to their concerns and worked with them to craft language that addresses those concerns. So the language before you today is the result of those meetings and has the support of the Illinois State's Attorneys Association. Last week, the House passed this constitutional amendment by a vote of 111 to 2. This amendment, in brief, it's HJRCA01, commonly referred to as Marsy's Law, gives victims the ability to enforce their rights in 2 ways. First, by giving them standing in the courtroom to assert their rights. Second, by removing the existing constitutional language that bars appellate relief for victims. First, subsection B of the proposed amendment expressly gives victims standing, but makes it clear that standing is limited to the assertion of the 12 rights enumerated in subsection A. There's express language that the victim does not have the party status, that the defendant does not have standing to assert the rights of a victim. Second, HJRCA01 removes the existing Illinois constitutional language that bars appellate relief. This language is not currently found in any other state constitution governing victims' rights. Together, these changes allow the victim to seek a remedy for the violation of a constitutional right. Enforcement of victims' rights is consistent with the U.S. Supreme Court recognition in 1803 in the landmark case of Marbury versus Madison that there is a legal right, there should be a legal remedy. Subsection B also makes clear that prosecutors retain their discretion by providing that the section does not alter the powers, duties, and responsibilities of prosecutors, and the language that prevents the defendant from using a violation of victims' rights to vacate a conviction or obtain other relief is retained. Finally, subsection B states that the court cannot appoint an attorney to represent the victim. The rights of victims will be enforced in the criminal case, not through a separate civil lawsuit for monetary damages. Language is added to subsection D that states that nothing in the amendment creates a cause of action against the state, counties, or their employees. HJRCA1 adds 2 rights to the current list of 10 rights. In response to reports that courts ordered the production and disclosure of victims' confidential privileged records without their knowledge or opportunity to object, the amendment gives victims the right to notice and court hearing before allowing this access to their records. The second additional right is that victims will be afforded the right to have their safety and the safety of their families considered when bail and other decisions affecting the release of the accused are made. 32 other states give victims constitutional rights. The experiences of states that provide for the enforcement of crime victims' rights show that defendants' rights are not diminished when victims' rights are respected, that courts are fully capable and routinely balance constitutional rights, giving full effect to each, and that procedures are established to ensure the continued efficiency of the trial in the appellate courts. I urge your support and very much appreciate the help of numerous folks, including the Senate President and Senator Bill Hayne, in getting us to this point today. Thank you.
Thank you, Senator Staines. Excuse me. Is there any discussion? Senator Murphy, for what purpose do you rise?
To the amendment, Mr. President.
To the amendment, Senator Murphy.
I just want to commend the sponsor for her work on this amendment and join her in applauding the doggedness of the activists in pushing this amendment to this point. I want to specifically reference one advocate by name, Jennifer Bishop Jenkins, who's from my area, who has worked tirelessly on this, who I have heard from specifically, and I want to commend her for her sticking to this on behalf of her sister, who I know you recently had an anniversary on. So congratulations to you for your efforts on this. I encourage aye votes all around.
Further discussion, Senator Rose, for what purpose do you rise?
To the bill, or to the constitutional amendment, excuse me.
To the amendment, constitutional amendment, Senator Rose.
I rise in strong support of this. unfortunately, I cannot see the lady, but I wanted to thank her for this. As a House member, I was one of the first sponsors on this way back when. As Senator Murphy just pointed out, Jennifer Bishop, who's in the gallery, has been through an experience that none of us would ever want to go through and would hope that would never happen again. As a former prosecutor, you do your best to work within the system and the rules that are there, but victims need this amendment. Every one of us, if you think back on your career, whether it's short or long, someone has come into your office and said that they were somehow a victim of crime and left outside the existing system. We're not allowed to give voice to their thoughts and their opinions about what should happen. From time to time, we tussle in this chamber, and that's fine. But on this one, the sponsor's absolutely right. The victims are absolutely right. And this, I can't tell you how happy I am to see this at final action here today. I hope, I urge, I entreat, let's make this unanimous to the voters. Thank you, Mr. President.
Further discussion, Senator Raoul. For what purpose do you rise?
To the resolution.
To the resolution, Senator Raoul.
I too rise in support of the resolution. I think adjustments have been made to this resolution from what was presented to this chamber before in a manner that protects a victim's right to be notified and to be informed, yet balances it with the traditions of the criminal court procedures in a way that does not compromise the ability for state's attorneys to carry out the work of the state. So I commend the sponsor and I commend the advocates who worked on this, notwithstanding the fate of it in a previous version. I voted no the last time this resolution was presented, and that was not in any way a signal of my sentiment towards making sure victims' rights are protected. And so I stand in strong support of this resolution and urge all aye votes.
Thank you. Further discussion, Senator Hayne. For what purpose do you rise?
To the constitutional amendment.
To the resolution, Senator Hayne.
I want to thank from the bottom of my heart Senator Staines and the advocates who worked for this bill, this amendment over the years. And it's important for us to pause a moment and realize that the opposition of the state's attorneys was not designed to obstruct any effort to reach out to victims. The primary duty of a state's attorney is similar to the primary duty of the governor, and that is to faithfully execute the laws of Illinois. There can only be one officer in charge of that effort in a jurisdiction such as a county, and that is the state's attorney. And the state's attorney's obligation is not to represent the victim. The state's attorney's obligation is to represent the people, the administration of justice, which may or may not be consistent with the desires of a victim. And it's important to recall that in this system. And this is not an uncaring view, but it's a deeply held custom of a constitutional order that protects the innocent as well as affords a means of bringing wrongdoers to justice. And this proposed amendment does not disturb that discretion. It is true that over the years, victims have been shunted aside in many of these decisions. This amendment will afford them an opportunity to be heard that's formalized. And it will remind state's attorneys that, yes, they have this duty and this discretion and this authority, but they should always be cognizant of the need to explain to a victim what is going on. The French Premier Clemenceau once said, "War is too important to be left to the generals." It is true that sometimes the law is too important to be left to the lawyers. And that's what this amendment does. I want to leave you with this thought. As great as this is, the first and the primary benefit or good that we can do for a victim is to bring the evildoer to justice that made them a victim, that victimized them. Those who shed innocent blood, who rob and rape and murder, should be brought to justice and punished. That is the duty of the law. Everything else is secondary. The first duty of the law, as the Romans said, is the safety of the people. Salus populi lex est prima est. And this amendment does not disturb that principle. And ladies and gentlemen, I stand in strong support of it. And again, I congratulate this senator, the House members, those who have spoken, and above all, the victims' advocates for keeping our nose to the grindstone. Thank you very much.
Thank you, Senator Hayne. Senator Staines to close.
Thank you, everyone, for the support on this. This really has been an enormous amount of labor going into it. And what we've talked about here, a lot of the conversation reflects sort of that need to keep balance. I think it's very appropriate. This week is the country celebrating the 30th National Crime Victims' Rights Week. And the theme this year is 30 years, restoring the balance of justice. I think HJRCA01 restores this balance in Illinois. We can't always stop violence or erase the pain we know that it causes to victims, but we can make sure at least today that their dignity and respect is honored during the criminal justice process. I want to ask a few folks to stand up in the gallery. Cynthia Hora from the Attorney General's office has spent years of her life working on this. Polly Poskin, I know, has been incredibly involved, as has Claudia Castro, I think, is here also. And then really last and not least, but most importantly, Jennifer Bishop Jenkins, who has already been noted, has really dedicated an enormous amount of her personal time and energy on this. And it is personal. I mean, we've been there, we've had a personal impact on it. Congratulations and on all your hard work. Thank you very much for being here today to see this come to fruition. Urge your aye vote.
Ladies and gentlemen, the question is, shall House Joint Resolution Constitutional Amendment 1 pass? All those in favor will vote aye, opposed nay. Pursuant to Senate Rule 6-2, this joint resolution requires a 3/5 roll call vote. The voting is open. Have all voted who wish? Have all voted who wish? Have all voted who wish? Mr. Secretary, take the record. On that question, there are 59 ayes, 0 nays, 0 voting present. House Joint Resolution, Constitutional Amendment 1, having received the required 3/5 constitutional majority, is adopted and is declared ratified.